Hello and welcome back to Supreme Court Now. Today we're going to be looking over the next two cases that the United States Supreme Court is going to look over during their November 2020 term. The first of these two cases is the United States Fish and Wildlife Service versus Sierra Club, and the second of these cases is Salinas versus the Railroad Retirement Board. We should remember that the Supreme Court now has 9 justices again. Justice Amy Coney Barrett sat in on her first case this morning, and she was given a quick introduction by Chief Justice Roberts. So with that, let's look at our first case, U.S. Fish and Wildlife Service versus Sierra Club. And U.S. Fish and Wildlife Service is a government agency, and Sierra Club is a preservation society or an environmentalist group, pretty prevalent in basically all 50 states. And so let's take a little look back here. In 2011, the EPA, or Environmental Protection Agency, proposed new rules for cooling water intake in order to help dissipate heat coming from industrial processes. So in a lot of port cities, there's a lot of industrial plants. So this rule was really put in place in order to combat all of the heat emissions that these plants are putting into the water. So the Environmental Protection Agency consulted with the U.S. Fish and Wildlife Service and the National Marine Fisheries Service, basically in order to review any of the possible impacts that this new rule could have on the environment. And so in fact, both services, the U.S. Fish and Wildlife Service and the National Marine Fisheries Service, write back a biological opinion to the EPA stating that, yeah, this rule is actually going to have more negative impact on the environment rather than a positive one, which is the entire point of making a law. So after corroborating and sending new drafts back and forth, in 2014, the three agencies finally come up with a solid draft, and both the U.S. Fish and Wildlife Service and the National Marine Fisheries Service send back a new biological opinion which states that, yeah, this rule is going to have a positive effect on the environment. Now, this is where the Sierra Club comes in. This preservation society says that they want to challenge the EPA rule. They think that actually these services had it right the first time. This rule is going to be harsh and dangerous to the environment, and thus we don't think this rule should be right. So we're going to sue the EPA and the U.S. Fish and Wildlife Service. And they're going to file a petition under the Freedom of Information Act. And they filed this in order to expose some of those initial drafts and show that this law, or this rule, should I say, is going to be detrimental to the environment. And the Freedom of Information Act was signed by LBJ in 1966, and the Freedom of Information Act allows American citizens to access previously unreleased information maintained by government agencies. And this act was created to replace the Administrative Procedure Act from 1946, which was basically the same thing, yet it allowed government agencies to choose the documents that they released to the American people, and so thus the Freedom of Information Act was created in order to stop this secrecy. So you can never say that the government's hiding stuff from us. So basically what the Supreme Court is going to be tasked with is seeing whether or not the Freedom of Information Act protects drafted or unofficial documents and correspondence between government agencies. And so we'll move on to the second case of the day, Salinas versus Railroad Retirement Board. And so we'll look back to 2006 when Manfredo Salinas filed for disability annuity with the Railroad Retirement Board, more specifically their Disability Benefit Division. When he initially applied for disability, he was denied in 2006, and he asked the board to reconsider, and the board denied once again. And so let's look to about 7 years later, in 2013, when he applied for disability once again. This time he was approved. And upon his approval, he appealed the initial date for the start of his disability and the amount. And he asked that the Railroad Disability Benefit Division reconsider his initial date of application. And as you could probably guess, they denied. And so with that, he appealed to the Fifth Circuit of Appeals in New Orleans, and there the case was immediately dismissed, or almost immediately dismissed, because the judge there said that they had lack of jurisdiction. Basically, it's an inside matter, and this has nothing to do with other courts. So with that, the Supreme Court has accepted to see this case, surprisingly enough. And the question they're going to be faced with is whether a final decision regarding a railroad denial of request to reopen a prior benefits claim is subject to judicial review. So I think that if the Supreme Court does decide that this case is subject to judicial review, they will be able to overturn any decision that the Railroad Retirement Board has made, thus possibly granting Mr. Salinas disability not just from 2013, but all the way back from 2006. So with that, we'll have to wait and see what the Supreme Court decides. And so those are all the cases for the first date of the new November session, November 2nd, 2020. Hope you guys enjoyed, and if so, make sure to be tuned because I will be covering all of the cases that the Supreme Court will be covering this term, and whenever they get around to it, their opinions on the cases as well. So, without further ado, adios.